this court. With the court's permission, I reserve 5 minutes for rebuttal.
Okay.
I'd like to, again, with the court's permission, focus my argument on grounds 1 and 3 in my brief. I'd rest on the brief as to ground 2. As to ground 4, having reread the Roberts case, which was cited by the state in their answer brief, I concede ground 4, at least that this panel is governed by the prior panel decision in the Roberts case on ground 4. I would preserve my argument, though, for purposes of rehearing in bank or if the Florida Supreme Court were to overrule Roberts. This case involved 2 criminal trials. At the first trial, the defendant, Reginald Luster, testified. He waived his right to remain silent. The first trial resulted in a hung jury. The case was retried 6 months later. And at the second trial, Mr. Luster exercised his right to remain silent. He had retained his Fifth Amendment protection against self-incrimination for a subsequent trial, despite the fact that he had testified and waived that right in the first trial. The issue then, during the state's rebuttal case, the state called a medical examiner as a rebuttal witness. And in the state's examination of the medical examiner rebuttal witness, the state sought to introduce as State's Exhibit 59 a video of excerpts chosen by the state of Reginald Luster's testimony in the first trial. That drew an immediate objection from the defense. And at pages 955 and 956 of the trial transcript, the defense attorney made clear that his objection was that it would draw attention to the jury if the jury saw that there had been a prior trial and that this was testimony from a prior trial, that the jury would then draw an adverse inference about the defendant's not testifying at this trial. Because again, this was in the state's rebuttal case. The defense is rested. The defendant had not testified. The judge overruled that objection, and the judge stated he saw no reason why the jury shouldn't be informed that there had been a prior trial. The state was then allowed to introduce State's Exhibit 59 and played the video to the jury. Again, the defense attorney made clear that his objection was that by seeing the video, the jury would see that this was testimony in the prior trial. The case is governed by Barnes, Florida Supreme Court decision. The issue is not whether the prior trial statements were admissible. The prior statements, qua statements, were admissible. The issue is the Fifth Amendment right in the adverse inference that the jury drew from seeing that the defendant had testified, had waived his right in the first trial and testified in a trial, and now was exercising his right to remain silent in this trial. That's the Barnes problem. And that's why
what Barnes was about, they called it the discrete issue that was resolved in Barnes, had to do with sending the transcript back to the jury. In no way did Barnes touch upon whether you have a constitutional right for prior trial testimony to come in a subsequent trial. And in fact, that issue has long been resolved, that you don't have a Fifth Amendment right to prevent your prior trial testimony from coming in a second trial, even if you invoke your rights at the second trial.
Well, I agree, Your Honor. That is, the statements that are made in the prior trial can be introduced, they can be read to the jury in a subsequent trial. But I disagree that Barnes isn't about the Fifth Amendment right. And at page 20 of my brief, I have a citation or quote from Barnes, pages 338, 339, and the court expressly adverts or addresses the Fifth Amendment problem. And they say that the problem is, and it says, although the parties may give great effort to conceal the fact that the testimony is actually from a prior trial, as occurred in the instant case, the jurors will most likely realize that on some occasion in the past, the defendant elected to offer an explanation and discuss what happened with regard to the alleged crime.
But did they say that the evidence, did the Barnes court say that the evidence was inadmissible because of that?
Well, Judge, we're not arguing that the evidence was inadmissible. The objection the defense made, in which we're reasserting on appeal, is the introduction as State Exhibit 59 of a video of his clearly testifying in a prior trial. And the jury, and we know the jury was aware, because already the jury had been made aware by cross-examination from the state that the defendant had testified in a prior trial, and that had drawn an objection as well, which was overruled. And so the objection here is, because I agree with you, the testimony is admissible. And I agree with the state's answer brief there that it's not a question about were the statements admissible against the defendant, whether he testified or not in the second trial. They're admissible, but care has to be taken. It has to be done in a way that the jury's not told or able to tell that these statements came from the defendant electing to testify in a prior trial. That's the Barnes error. Now, it's true in Barnes the transcript was actually taken back into the jury room, but the court in the holding, the Barnes say, and they use the conjunctive. The error was letting the jury know that it was testimony from a prior trial and letting the transcript go back into the jury room. So that's the problem here, and it's compounded. If I can go to issue 3 or ground 3, this ties together because the state, from the very first witness, the victim, Gabrielle Stroud, she testified at this retrial, unlike her testimony in the prior trial. The first thing she said was, when the resident assistant came into the dorm room and found the two of them there, she said that Reginald Luster said, "Call my father, he's a lawyer." Now, she had not said the "he's a lawyer" part before. The defense immediately objected to that on the grounds that it was a comment on his right to silence and invocation of his right to counsel. That then became sort of a leitmotif on the state's part in their case.
It's an interesting issue, but, at some point in any kind of case, I think that just as part of the facts that led to a defendant's arrest, there may be some information regarding, I should get a lawyer, you better get a lawyer, something along those lines, which have nothing to do with the state investigating the case. They just simply have to do with, facts that were part of the facts that led to a criminal charge being made. So where would you suggest that the court draw the line between a potential future criminal defendant mentioning the fact that he should have a lawyer,
Well, there's more.
and on the other end, obviously somebody in custodial interrogation specifically invoking his right to counsel? Where should the court draw the line as to what's permissible and what isn't?
Well, here we can draw it on the facts of this case, where the state expressly listed this from the cross-examination of Dr. Harper. When Dr. Harper, who was the defense expert, was on the stand, the state brought out through Dr. Harper, and this was completely unnecessary to the state's investigation of the case, that Dr. Harper had read in the nurse's notes when Luster was in the hospital that Luster refused to answer questions until he spoke to his father. And the state did that only after they had first brought out from Dr. Harper on cross-examination moments earlier that Luster's father was a lawyer. So the state expressly, intentionally brought out that Luster was refusing to answer questions until he spoke to his father, who was a lawyer. And then in closing argument, that's what the state hit on, that when the gig was up, he asked for his dad, the lawyer. So, Judge, that's just the facts of this case, which are pretty unique. And you combine that then when the jury, we know the jury knew because one of the jurors came immediately after the video was shown. One of the jurors came forward in a recess and told the judge, "I know that this is a retrial." And so the jury knew this is a retrial. They know then this is a video of the defendant's testimony in the first trial. This is exactly the problem in Barnes. The only difference is it was a video instead of a transcript. And the jury's being told by seeing the defendant on the witness stand in the same courtroom that he testified in the prior trial, which they know now existed. The state argued that the defense invited this here because I think it's at page 978, 979 of the transcript, that the defense asked or agreed to a stipulation be read to the jury in the closing jury instructions that this was a retrial. But they said in doing so, this was only after the court had already overruled their objection, their express objection on the implication of the Fifth Amendment right, the adverse inference objection. They said, "We're not waiving our objection to the admission of the video," and the judge said, "I agree and I understand." This is at page 979 of the transcript, I think. So, Judge, I think these two errors together, if not singly, entitle Mr. Luster a new trial. This case is not nearly as complicated as the cases the courts heard earlier today. It's much simpler, both in the law and the facts, but the consequences, significance is much greater. Because this is a defendant's constitutional right to remain silent. The jury's not supposed to draw any adverse inference from that. The state's not permitted to emphasize his electing to exercise his right to remain silent. And that's
Let me make sure I understand exactly what happened here.
Yes, sir.
Again, I'll put it on a spectrum. Let's say you and I are friends, and we're speaking, and you ask me, did you kill that guy? And I said, well, I'm not talking about that. Don't ask me any questions about that. I don't know if I would ever consider that an invocation of my right to silence, because it's not a question of whether a confession is being coerced. The whole point of the Fifth Amendment is that you can't be compelled by the state to be a witness against yourself. And of course, I don't need to tell you about the other end, would be some sort of, forced confession by the police. Again, this isn't, from what I can tell, there weren't any officers involved in this. This was just simply a non-custodial environment where somebody who's not a police officer asks a question, and your client says, refuses to answer any questions about it. How is that a violation of his right against compelled testimony?
Well, Your Honor, whether it's that or not, and we cited, and I would rely on Hoggins, the Florida Supreme Court decision. Hoggins expressly says, and this was not a statement to an officer, pre-arrest, pre-Miranda silence is inadmissible. This is a holding in Hoggins. Is inadmissible.
Pre-arrest? Hoggins
Yes, sir.
says pre-arrest silence is inadmissible?
If the defendant doesn't testify in the trial inconsistent with the silence. Lester didn't testify, so that is in Hoggins. I cited it in the brief. And so I think Hoggins requires reversal. That's not a Fifth Amendment question. It's just under the Florida Rules of Evidence. You can't use pre-arrest silence, which is ambiguous, as affirmative evidence when the defendant hasn't testified. It's only admissible under Hoggins if the defendant has testified and the silence would be inconsistent with his testimony at trial.
So in the example I gave, would that be
a Hoggins violation if he didn't testify at trial.
Yes, Counsel, I hate to go into your rebuttal time. Maybe we'll give you more time, but I thought there was a reference to the father being a lawyer in the dorm room at the time.
Yes, sir.
Someone heard it at the time.
That's where it first came. The very first witness was the victim. She testified uniquely in the second trial. She had not done so in the first trial. He said, call my father. He's a lawyer. Immediate objection from the defense. At sidebar, I think it was, they stated their reason, which implies his right to silence.
And then it came up in the notes as well, the nursing notes.
And then the state brought it out after the defense objected there to the nurse's notes when the state was cross-examining the defense expert. The nurse's note said he refuses to answer questions until he speaks to his father.
So in the first trial, there was no reference to either of these, the comment or the note.
There was no reference to the father being a lawyer. I'm not sure, Your Honor.
And the father didn't testify in the first trial.
No, sir, I don't think so. Judge, I'm sorry, I don't know.
Well, I mean, it's important in my mind because if it was not a feature of the initial case and now the state has brought out this information tangentially, and then the father goes on and feels he has to testify in the second trial, which he did, that's troublesome.
Well, I'm pretty sure that the father didn't testify in the first trial, but Judge, I can't say that with 100% certainty. But I do know that the objection that came as soon as Ms. Stroud gave this testimony about call my father's lawyer, at sidebar, the objection was that this was, the defense felt that perhaps this testimony had been fabricated, that the statement never been made because this was new. She never said this in her prior statements to the police. She never said it in her deposition. She didn't say this in the first trial. And so that much I know, and that was the state of the record, and that was the base for the defense objection. Thank you.
Thank you. And we'll give you your full 3 minutes on rebuttal, so add an additional 2 minutes or a minute and a half to the state's time. Give her a total of 16:30.
May it please the court, Virginia Harris on behalf of the state. I'm going to start with the second issue that he was talking about first. First of all, Hoggins, the case he's talking about, it precludes the use of appellant's pre-arrest, pre-Miranda silence interactions with police. None of these interactions were with police. And also, as noted by the dissent in Horwitz, which relies on it, the Hoggins case was decided before Salinas. The United States Supreme Court case that says that it is okay for the state to use that. And of course, you're not bound to follow the United States Supreme Court case, but it is highly persuasive. But in these examples, first you have the victim, Gabriella Strood, while she's in the dorm, before the police even get there, says that she ultimately states, once you look at her direct and her cross-examination, that the defendant said, she tried to stab me, call my father, he's a lawyer. So when you look at the whole statement, it is not really, doesn't really make the defendant look bad, because he's saying that she stabbed him. So while normally saying, I want to speak to a lawyer, could be arguable consciousness of guilt, in this circumstance it's not, because he says she tried to stab him.
What kind of lawyer is he?
A civil lawyer. He testified personal injury, so I'm not
That
really.
would be consistent with your interpretation of that statement, that it was, she stabbed me, call my
Yeah.
lawyer so we can sue her.
And then also, the state never argues or suggests that this is a consciousness of guilt. Like in Horwitz, for example, the state suggested that the defendant didn't say anything because, it was his consciousness of guilt. The state never said anything like that.
Did the state say anything about the statement that he said, call my father, he's a lawyer? Did that come up in
The
closing?
state, and I invite you to look at the whole closing arguments. The state did say the victim said that, but she made no argument about it. In fact, the only one who made it a feature of the trial was the defense attorney, who talked about it extensively in her closing argument. In rebuttal, the state doesn't even mention it again. So all she says is that Gabriella Strood said it. She never argues it improperly or argues that it's consciousness of guilt. But like I said, they're not talking to police. There's no case law I've ever seen that said this applies when you're talking to someone other than police, even the case law that he relies on. And I realize I have a printed out copy here, so for me it's on the last page. For you it'll be a few paragraphs above the certified question, so it's up in the Florida Supreme Court. But it says it applies to the interactions with police. And then the second statement, and it's also important to note that it comes out in the trial through the defense attorney that the victim also lawyered up, because when the defense attorney is impeaching her about the fact that she never said this before, she brings up that the lawyer was there at a deposition and then notes in the closing argument that the victim also had a lawyer.
At the first trial, did these statements, either the one where he said at the time of, shortly after the time of the incident, allegedly that you need to call my dad, and then the nursing notes, did that come up in the first trial at
The
all?
victim never said that before, but I actually think that benefits
So
the
the
state.
answer is no.
Right, because this was pretty much.
So why did the state choose to do that in the second trial?
Well, the victim said it. I don't even know that the state knew she was going to say that. The victim had never said that before.
But the state, through its expert, I guess, or someone looking at the notes, the state chose to bring it through that as well.
No, and that's where we argued that he opened the door. And this is in my brief as well. The defense presented Dr. Harper, and Dr. Harper repeatedly said that the defendant did not have the ability to answer questions, suggesting that he was so hurt that he wasn't able to answer the questions. And so the state introduced testimony of the nurse's notes, which the doctor had indicated he reviewed the medical record, that said that the defendant was just choosing not to talk until he spoke to his dad. So the state wasn't offering this as a consciousness of guilt. It was offering it to rebut defense counsel's innuendo that the defendant was so injured that he didn't have the ability to speak. And those are the grounds that the judge relied upon to allow it. And once again, they're not talking to police. He's talking to medical staff. In fact, according to the defense's own case, the defendant wasn't even arrested at this point.
But the expert had no firsthand knowledge, so these nursing notes are.
He does. And this argument that they're making now was not preserved at the trial level, and probably the reason why is for the information.
But you're saying your expert was present at the time the nurse made those notes?
Yes. And what you'll see is if you look at volume 4, page 716 of the Judge Lewis trial, and I'm not talking about the transcript. The way this record is set up is there are volumes that say Terry Lewis, and then they start over from one with Judge Hankinson, and then they start over from one again with the transcript. So I would be referring to the record of Terry Lewis, and it's volume 4, page 716. Harper testified that he received the trauma flow sheet and that the nurse is essentially writing that in the room with you in there. So he's indicating that in this other trial that the nurse is in there when she does this. So the defense would not want to bring this up in the second trial because the state could even worsen the impeachment of the doctor by saying, yeah, but you said in the other proceeding that the nurse is in there with you while she's taking these notes. And then also, if you look after the objection, they mentioned another note from a doctor that said the defendant only had difficulty flexing his fingers. And the doctor said, yeah, but I didn't rely upon that. He didn't say that when they were talking about the nurse's notes. He distinguished that, which suggests that he did in accordance with what he said in the first trial. So the state...
Well, tell me why the trial judge allowed the father to testify.
Why
Did the trial judge allow the father to testify? What was the relevance of the father's testimony?
The father of the defendant testified, it sounded like essentially to say that he went to the hospital, he saw his son, and he talked about his injuries, and then he also indicated that he had no prior or not much of a prior relationship with the defense experts. He actually wasn't really that relevant to the case.
Well, it sounded to me, and I haven't read every page of the record, it's very lengthy, but it sounded to me as if he was feeling compelled to testify because these comments about I need to call my dad or I want my dad had been brought up and were made a feature of the trial and were mentioned in closing by the prosecutor.
No, I don't agree with you. I've read the
What
closing.
don't you agree with?
I read the closing twice, last night, in fact, being the last time, and I did not see that the prosecutor made it a feature, ever argued consciousness of guilt, that the prosecutor ever acted like, in fact, the only time that I saw that the prosecutor mentioned it was in the initial closing. The prosecutor says that Gabriella Street, or the evidence said that he said that, but makes no argument about it, just says it was said. And you're permissible to comment about the evidence. The prosecutor never argues consciousness of guilt, never suggests in any fashion that the defendant is guilty because he, didn't want to talk at the hospital or something like that. In fact, in her rebuttal argument, the prosecutor says, you know what, it really doesn't matter how injured the defendant is, because you have to remember the victim said he tried to kill her and then tried to kill himself. So the state was really going after Dr. Harper because his testimony was inconsistent with the other evidence. But it really doesn't matter how injured the defendant was because the state's theory included that he tried to kill himself after he tried to kill her. And the victim said he looked like he was serious about it. So really, why does it matter how injured he was? And the prosecutor says you shouldn't feel sorry for him if he was more injured than the victim, because that issue really didn't have anything to do with the case, except it is just a further attack on the credibility of Dr. Harper. Dr. Harper had raised the eyebrow of the state because apparently the defendant's father created the doctor's statement, and the doctor just adopted it. And I'm not going to accuse the defendant's father of anything, but that's highly unusual. Usually lawyers try to keep a distance when witnesses are filling out statements, and they certainly don't write the statement for them. Then the doctor says that the defendant didn't have the ability to answer questions, which is contradicted by the nurse's notes, which he indicated he read that record and never said he didn't rely upon it, as he did with the other doctor's notes. And then the doctor says the defendant did not have the ability to flex his finger, and the state presents him with a picture showing that he's flexing his finger, which he was unable to account for. So that whole scenario was really about the state going after the doctor because they didn't find him credible. And the actual issue of how injured the defendant was didn't really matter that much.
Well, how can you say the state didn't make it a feature of their case when in the first few minutes, the prosecutor says to the jury, call my dad, he's a lawyer. That's the first thing he says. That's the prosecutor's word.
How is that arguing consciousness of guilt?
Well, that may not be arguing that, but it's arguing to say, well, this guy wants to lawyer up, and so he must inferentially have something.
Well, I invite all three of you to read the closing, all of the closing arguments. I did not see where the prosecutor argued consciousness of guilt, that the prosecutor ever suggested. And like I said, there is absolutely no case law that says that a defendant talking to non-law enforcement before law enforcement's there or before there's any kind of custodial interrogation would involve the Fifth Amendment. I've never seen any case law that said that. But I don't think that the state argued that. I don't think it was a feature of the
I'm reading the transcript, so.
And then I think the other issue that defense counsel raised was about the video testimony. And initially they objected to the video testimony, but then the judge said, hey, you know, this would be sort of like your client gets to testify, you know, even though he's not really testifying. And there are some reasons that they would have wanted that testimony in, because the defendant claims that Catherine Palmer, you know, saw him going like this because he was beating off the victim's hands, and that the victim's blood was on the wall because she fell. And those statements would not have come in had the state not been able to introduce this. So it would have been more difficult, not impossible, but more difficult for the defendant to present his theory of defense.
Counsel, I'm going to go ahead and take appellant's word for it that they didn't want this, evidence in. I think they certainly seem to have objected consistently. But my question is, I look at the Barnes case, and it looks to me like in that case, the state made a lot of effort to conceal the fact that these statements of the defendant that were coming in at trial were not from a prior trial. And, you know, they just did it by transcript. I believe they read it into evidence. And forget the part about it going back to the jury. So, but again, that's all that came in to the jury at that time was just transcript and read back of the testimony. So in this case, we have an actual video of him testifying. And yeah, I think the appellant is correct that there's efforts that are supposed to be made to attempt to try to let the jury know that this isn't from a prior trial. It doesn't look to me like any attempts whatever were made.
The only reason the jury knows it's a prior trial is because defense counsel asked the judge to give a curative instruction explaining that it was from a retrial and that they should not hold it against the defendant.
Well, it seems, I mean, if the video is going to come in, it seems to me that the defense doesn't have much
You'll
choice.
notice, and this is actually quoted in my brief, that the defense attorney towards the end says, we have no problem with the video coming in if you'll just stipulate it's from a prior proceeding. Well, if you can cure the prejudice by stipulating it's a prior proceeding, then it must follow that you can't.
I thought there was more excuse me. I thought there was more discussion among the counsel about it than just that one simple statement you're giving. I thought there was more discussion about we're really concerned about this, and yeah, maybe it will come in, but we want these safeguards.
No, what I'm saying is he says, I want you to tell them this is from a prior proceeding. What that means is you can't tell from looking at the video it's a trial. Because if the defense attorney thinks that it can be cured by saying it's from a prior proceeding, then it means the jury couldn't tell by looking at it.
I don't know if the video's in the record here or not. I assume it is. I haven't looked at it. But it's going to be awfully hard to do that. It seems to me that a transcript at most would have been permissible.
You can't, because, and if you look at the transcript, the defendant does a lot of indicating about what happened. And the court reporter actually indicates a few times he's indicating, and then sometimes he'll say, my hands were like this. And it doesn't say indicating, but he must have been, because how else could he be explaining what he's doing? Then that's why the state wanted the video in, because their expert was in part rebutting his argument by saying what he indicated wasn't plausible to her. So how could the state have done that if they introduced a written transcript?
Did he actually demonstrate how the
They say, when you read that portion of the court reporter several times writes indicating, and then sometimes the defendant, you can tell when he'll say, my hands were like this. Well, how else is he telling them unless he's indicating how his hands were? And that's actually the argument that the state used. And then I also noticed.
Excuse me, how did it come to be that the first trial there was a video of it? That's not common.
I think, I mean, I've had cases where it was videoed before. I was noticing, because I was reading the Barnes case.
But that didn't answer the question.
I mean, this actually it kind of does, because it says, the Barnes court notes, in Young, this court held that trial testimony presented through videotape to a jury should not also be permitted to the jury room as an exhibit. So what they're saying is it's kind of a similar thing. We don't want videotaped interviews entered as an exhibit so that they would have unfettered access to it. And I didn't go back and read the Young case because I was just noticing that now. But when you
Still don't hear
print
an
out,
answer to the question. How did that get it? Was it done by a official court reporter? Was it a television station covering it?
I don't see where the record says how it was. I mean, many courthouses have the trial recorded, so I would just presume that this would be one of those courthouses. There's no indication who did the recording, but there are courthouses where it's done. But the fact that the Barnes case mentions, and it's on page 4 of my printed out copy of Barnes, in Young, this court held trial testimony presented through videotape to a jury should not also be permitted to the jury room as an exhibit, indicates that this has happened before, and that they too did not like it being introduced as an exhibit so that there would be unfettered access. But if the state...
Wrap it up.
Oh, okay. I guess that's pretty much, since I only have a few seconds left, the state asks that you affirm.
Thank you, counsel.
May it please the court. Just one quick point. I think Ms. Harris said at one point that the defense, in response to my argument on ground 3, that the defendant had not preserved this objection, the error was not preserved. But the answer brief, page 45, correctly takes the position that ground 3, this issue is fully preserved. There's no preservation issue. And as to the jury instruction, I think with all due respect to Ms. Harris, I think she's got the record wrong. Page 979 of the second trial transcript is where they're discussing the jury instructions and the proposed stipulation. And the court says, referring to the stipulation, the court will call it kind of a jury instruction type of thing, Mr. Akbar, the defense attorney, and we're not waiving our objection to the video being shown. We just want to clear it up as much as possible. The court, I understand.
Well, should we give the stipulation, what was read to the jury about this prior proceeding, don't hold it against him for not testifying today, should that weigh into our analysis of any harmless error, or is this per se reversible error in your view?
Well, Judge, I don't think it's per se reversible error. I think you have to look at whether the error is harmless or not. I mean, it's a harmless error standard, constitutional error. So I wouldn't say per se. I suppose it weighs into it, but this wasn't like a cautionary instruction. This instruction, as Judge Winokur said, the cat's out of the bag at this point. So the defense is trying to deal with it as best they can. The judges said, I see no problem. I'm going to tell the jury that there's been a trial before. This is a retrial. And right after this issue of the video came up during the recess, they did a recess as soon as the state had entered the rebuttal of Dr. Flanagan. One of the jurors came to the court during the recess and said, Judge, I want y'all to know, I know this is a retrial, and I don't think it'll affect my determination in this case. The juror was allowed to stay on the case. There was no voir dire of the remaining jurors. Had there been any discussion, the juror was not asked if you said this to any other jurors. But at this point, clearly the cat's out of the bag, at least to that juror. The court's let that juror stay on the jury. And so this instruction has been given. I don't think that instruction that was given, saying that this is retrial, if anything, it harmed rather than helped. It was not a curative instruction. The judge didn't give an instruction in any way to try to deal with the Barnes problem. And I think in weighing the determination, well, did they have to show this video? No, they didn't. Did they have to show this video in order to get across their examination, Dr. Flanagan? No, they didn't. All this video did was, it let the jury know beyond any doubt whatsoever that the defendant had testified in his first trial, and he had offered, and these are just selected excerpts, the state's picking selected excerpts of his testimony in the first trial, and they're showing those to the jury, and the jury knows now, he gave some explanation in the first trial, we're not hearing from him here. And that's the Barnes problem. Judge Maker, I don't know the answer. I had the same question. I don't think in Tallahassee these trials are ordinarily recorded by video, and I couldn't find out an answer to it.
All right, thank you, counsel. All right, that concludes our docket, and so we will be adjourned.